Hi, my name is Melissa Overman, and I chose the case Florence County School District 4 versus Shannon Carter. This case took place in South Carolina beginning in 1985 and ending in the Supreme Court in 1993. This case solely focused around the Individuals with Disabilities Act, IDEA. This act includes two major points. First, to provide a free, appropriate public education, FAPE, to children with disabilities. And second, to give parents or legal guardians a voice in their child's education. IDEA supports the case Florence County School District 4 versus Shannon Carter because of the issues that were presented by the parents of Shannon Carter. With that, let me give some background information of Shannon. She was privately educated until she was the age of 13 when she was enrolled in FCPS. She was a ninth grader who was reading at a fifth grade level. Her initial evaluation suggested that her academic deficits were due to a lack of motivation rather than a learning disability. She was functionally illiterate who became depressed and felt hopeless. She was finally reevaluated and diagnosed with ADHD and dyslexia. With this diagnosis, the school developed an IEP under the IDEA law stating that Shannon would stay in a general education class but would be pulled 3 periods a week for individual instruction. Shannon's academic goals, according to the IEP, states Shannon would progress from the 5.4 to the 5.8 grade level in reading and from 6.4 to 6.8 grade level in math. This goal projected Shannon would make progress of 4 months by the end of the school year. The parents were extremely unsatisfied by the school's proposed IEP and asked for a more intensive program. FCPS denied the request, unfortunately, and Shannon's parents enrolled her in Trident Academy. This was a private school that specializes in academic instruction for students with disabilities with a strong focus of dyslexia. The Carters then filed a civil lawsuit against FCPS in federal court, suing them for tuition reimbursement for the time Shannon spent at Trident Academy, claiming that the school district had breached its duty under IDEA. This case has a constitutional question, and that question is, are parents stripped from reimbursement because they unilaterally withdrew their child from a public school that provides an inappropriate education under IDEA and put the child in a private school that provides an education that is otherwise proper under IDEA but does not meet all the requirements? So the question is, if a parent decides personally, by themselves, without any help, that their child is not receiving an appropriate education, that they can remove that child from that school and place them into a school that they feel is more appropriate for that child, should they be reimbursed or not? This case helps answer that question, and it did change the future of special education. Once the parents filed the civil lawsuit against Florence County Public Schools, it went to the District Court of South Carolina. Judge Hoke was in charge of the case, and he dismissed it, asserting that the statute of limitations had run out for the appeal of the due process. However, during this time, Judge Hoke then reversed the case because he concluded that FCPS's IEP was actually wholly inadequate after reviewing Shannon's educational test data. So then the trial court ruled in the parents' favor. So the case then moves on to the U.S. Court of Appeals. Florence County Public Schools appealed the decision, arguing that 4 months of progress in reading was appropriate. They also stated that Trident Academy was not on the state's non-existent approval list of schools. They claimed that because it employed at least 2 faculty members who were not state certified and that it did not develop IEPs, that it should not be considered a state-approved school. So in a unanimous decision in Shannon's favor, because the Court of Appeals stated that Shannon's education was appropriate under IDEA and that Shannon's parents were entitled to reimbursement of tuition and other costs, it created a split decision that needed further appeal. With that further appeal, our case then moves on to the U.S. Supreme Court. The case is now in the U.S. Supreme Court, and the Supreme Court agrees with the Court of Appeals, who noted, quote, "It hardly seems consistent with the Act's goals to forbid parents from educating their child at a school that provides an appropriate education simply because that school lacks the stamp of approval of the same public school system that failed to meet the child's needs in the first place." The Supreme Court is simply saying, who cares where the child gets the education from, as long as the child is getting an appropriate education? Whether it is state approved or has that official stamp of approval, the child is getting and exceeding her goals, so the parents should be reimbursed. The last thing that we want to do as a court and as an education system is to fail a child. So Justin O'Connor held the state responsible to pay for the education at a private school when a public school fails to comply with FAPE, free and appropriate public education. She then issued a unanimous decision of 9-0. Opinion of the court. So the U.S. Supreme Court states that two issues were settled. First, the school district's proposed IEP was in fact inappropriate under IDEA. And although Trident didn't meet the requirements, it provided an education proper under IDEA. The justices held that if a public school defaults and the child receives an appropriate education in a private placement, the parents are entitled to be reimbursed for the education that should have been provided by the school district. This case set a precedent for children's education under the IDEA Act. It helped parents form a better understanding that their placements are not and should not be held to the same IDEA requirements that public schools are. That parents should be requesting reimbursement when a free and appropriate education is violated. And lastly, parents have the right to search outside the approved schools list if the education provided is appropriate and proper under IDEA with tuition reimbursement. Thanks for watching, and I hope you enjoyed and maybe learned something about the Florence County Public School District 4 versus Shannon Carter case.